So today I'm going to talk about the impact of the new laws that are being passed just the last 2, 3 years on the child's preferences and the ability of the courts to deal with that. Because children having a major say in what the decisions are in families with alienating behaviors is basically a disaster. And so I'm going to go over this and talk a little bit about the laws and then talk about the child's opinions and where the opinions come from and why their opinions cannot be relied on, should not be relied on, but are encouraged to be relied on by these new laws. So let me start out by saying the new federal law, Kayden's law, uh, I'm going to speak about it briefly and a couple state laws that follow that. Briefly, because later there's going to be a 2-hour session um, on Kayden's law and its impact and how to deal with that. So I'm just talking here, kind of briefly introducing it and talking about the children making decisions and the troubles with that. So first of all, Kayden's law, it was signed into law basically 2022 as part of the Violence Against Women's Act, the reauthorization for that. And it focuses really on child abuse and domestic violence and concerns about safety for children. And it's true, there have been children murdered in some cases when the court placed them with a dangerous parent and disregarded the other parent's concerns. So this is driven completely by concerns about these cases, and they're very powerful. And we have to acknowledge that child abuse, child sexual abuse, domestic violence exist and are problems that need to be addressed. The whole problem here is it's like one hand clapping. There's another half of the picture missing, and that's the issue of when a child resists being with a parent because of the other parent's alienating behaviors. And so these laws are a real setback. I'd like to say, from my experience, I became a family lawyer in 1992. And so that's 32 years. And I was a family therapist basically 12 years before that. And I think we're back to the 1990s. Cases I was involved in included allegations of child sexual abuse, as well as false allegations of child sexual abuse. And so that was a lot of what was going on in family court in the 1990s, as well as in the country and the culture. There were concerns about daycare workers, et cetera, molesting children, school teachers, Sunday school teachers, all of that. And what came out is a significant percent of those cases were not accurate, and that children's testimony had been influenced by those who were interviewing the children. So that was a big problem 30 years ago. And I would say that family law professionals, there's certainly a portion of family law professionals that believed that parental alienation didn't exist, that alienating behaviors didn't exist, and it was only used as a defense by people who were engaged in child sexual abuse, child physical abuse, and domestic violence. Well, I would say by the early 2000s, that family law professionals were starting to see so many cases of alienation against fathers and against mothers that they realized this really exists and this needs to be addressed and needs to be understood, as well as child abuse and domestic violence. So over the last 20 years, I think, the profession is almost completely um, understood that there are alienating behaviors. How you deal with each case is the question, but that's certainly something to consider. So I think we're back where we were in the 1990s, and this has to get addressed pretty quickly. And I know you're going to have a 2-hour session on that later. Anyway, so Kayden's law focused on purely on child safety from child abuse and domestic violence. Other states have picked it up. The way it works is it's really about giving more money to states who adopt a set of rules. And so California, Tennessee, Pennsylvania, where Kayden was murdered, Colorado, Arizona, Utah, Maryland, all these states have adopted forms of Kayden's law. Because it's a federal law and states handle family decisions, the federal law can't tell states what they have to do. So instead, they say, if you want more federal money, this is what you have to do. And many states, of course, have followed that. So essentially, the name of the law, Keeping Children Safe from Family Violence Act, basically looked at three key things. One was restricting expert testimony. So only experts in child abuse and domestic violence can really be considered. And this is a real superficial, overview. But the idea is that they have to have experience, basically clinically, working with child abuse and domestic violence, as well as not just as an expert in legal cases. Secondly, limiting the use of reunification camps and therapies. And third was providing evidence-based ongoing training for judges and court personnel. And the fourth was if there are protective orders, and some of these child murder cases had protective orders, but they were not considered a reason not for the other parent to have time with the child or to have supervised. So they were unsupervised alone with the child and murdered the child. So these four key things, main concerns. I have to admit, as a lawyer doing research, it took me a couple hours to find where Kayden's law was buried in the federal laws. And it turns out it's under 34 USC, United States Code, section 10446. And that's where all these restrictions come in as required if they're going to give more money. And so a big part of it is those four things: restricting expert testimony, limiting the use of reunification, providing training. But there's some key words in here that are going to impact the children basically having power to make these decisions. They're where they are with parents. So, of course, the expert evidence from court appointed, et cetera, they have to have work with, not just forensic contact in cases. So they've worked clinically with that. And that the laws that they want put into the states, a court may not remove the child, court may not restrict contact. A court may not order the reunification treatment, and unless it's a generally accepted therapeutic method, and that's controversial, and that they can't have reunification treatment that involves cutting off the child from a parent, quotes, with whom the child is bonded or to whom the child is attached. Now, we know that parents with alienating behavior Often, certainly the child is bonded with them. Certainly the child is attached with them. It may be an insecure attachment, so the child's working hard to keep that going. And that can be the problem. And that's what I'm going to get to, is the dysfunction of dysfunctional families that the children are under the influence of in cases of alienating behaviors. Then the law also says that the court can't order to remediate the resistance of the child. In other words, unification treatment. To have contact with a violent or abusive parent until that person primarily addresses their behaviors. So here's what's confusing is there's domestic violence and child abuse, certainly. There's alienating behaviors, certainly. Now, there may be a combination. I've had cases where there's a domestic violence perpetrator who also alienates the children against the target parent. So all of this exists and has to get sorted out, but this is cutting off half the analysis. And so you can't order a parent who hasn't been found to be violent or abusive to get counseling or other efforts to improve the relationship of the child with the other parent until the other parents had treatment for their child abuse or domestic violence. So everything prioritizes, not just prioritizes, eliminates the idea of alienation and alienating behaviors. California. So California's adopted Kayden's law, and as you'll learn later, they have names for each state. It's PICU's law, I think, for California, and it's Abriel's law in Tennessee, and it's all about specific cases. One of the things I want to mention now, just scientifically, is this is not the way you do science. You don't just say there's only one possible answer to a problem. You go, what is the answer to the problem? Rather than, is this the answer? That's called confirmation bias. And this approach assumes that the only issue that exists is child abuse and domestic violence. That judges, and here's an interesting thing about judges, get training, and professionals involved in these cases get training. But the bottom line here, that the training focuses solely on domestic and sexual violence and child abuse, and gives a list of several examples. In other words, there's to some extent forbidding education about alienation. And of course, that's disastrous, since we see, many more cases of children resisting being a parent because of alienating behaviors rather than resisting a parent who's likely to murder them. So that's what's been really troubling about all this. Anyway, so let's talk about children's preferences. Now, I'm a California lawyer, California licensed clinical social worker, and I've been addressing these issues as a clinical social worker since 1980 and as a lawyer since 92. And children's preferences have always been understood to be under the influence of parents, and that they can be considered, but that they certainly don't make the decision. And I remember early on one of our trainings given by the judges in our family court in San Diego, and someone said, at what age can the children decide where they live, which parent they prefer, all of that? And the judges said just right away, 18, because that's the age of majority in California. And it surprised people. The rumor had gone around that 14, a child can decide. I actually had a case where in this case, a father pressured 14-year-old girl to change from living primarily with the mother to come live with him. And the mother agreed, This is a post-divorce case. Um, but the what the father did is he says, I'll give you a trip to Alaska, the Inland Passage cruise, which, by the way, is a really fun cruise. But for a 14-year-old, she's basically being bribed. And within a few months, she figured out that he wanted her to babysit his new child with his new partner. And so, what a 14-year-old says they want to do is subject to a lot of influences. And so, in that case, eventually various things happen, and the time went back more with the mother, and then the father moved to live near the mother, and everybody had time with the child. But it's just an example to me of how malleable a 14-year-old is. Many of our resistance cases have to do with children between 9 and 14. And as a previous family access webinar I gave explains, between 9 and 14, the child's brain is getting reorganized. It's the biggest reorganization of a child's brain since around 5 years old, which is a big reorganization from birth. And what's happening is the brain is pruning some of the synapses that have to do with the past. That's creating space in the brain for new experiences, kind of clearing out some of the unused ones. And if a parent has been rejected by their child for a year or two or three, who knows how much of those memories are getting impacted. And I know of cases, where, for example, a grandmother told me, said, my grandson, I finally got to see him when he was 16 after not seeing him for 4 years, something like that. And he said, I don't really remember you. And that was quite tragic for her. And she had photos, and he looked at those and says, yeah, that's me. But it's all vague. And I think that could be the explanation, is this lack of contact in the brain during this time period. This is a lot of when we see resistance and refusal, 12, 13, 14-year-olds, that they've really started to shift, and they've really absorbed the intense emotions of a parent with alienating behaviors. Because in many ways, the child's brain is being opened up to emotional experiences. But ideally, those are more with their peers, learning their place with their peer group, learning their place in society. And so the brain is really opening up for that, and it's getting filled by a lot of the emotional intensity of the favored parent. And so the child really locks in with that favored parent. And that's part of why it seems to be all or nothing thinking, that favored parent's perfect and wonderful, which comes from the emotional connection. And the rejected parent, who they haven't seen maybe even for a year or two, is terrible for all these vague reasons. They absorbed emotions without really understanding why. And so they come up with reasons, like cases I had where, I never want to see my father again. And well, why? Well, the way he wears his hair embarrasses me. Or I never want to see my mother again. She's no good at math like my father is. So they come up with reasons because their brain is trying to make sense of the emotions they've absorbed. So, children's preferences. In California, Family Code Section 3042 talks about the child's role. Now, it doesn't say the child gets to decide, but it says if a child is of sufficient age and capacity to reason so as to form an intelligent preference as to custody or visitation, then the court shall consider and give due weight to the wishes of the child in making an order granting or modifying custody or visitation. So here's the question. How do you decide if a child is of a sufficient age and capacity to reason so as to form an intelligent preference as to custody and visitation. Doesn't give an age there, but down a little bit. If the child's 14 years of age or older and wishes to address the court regarding custody or visitation, the child shall be permitted to do so, unless the court thinks it's not in the child's best interest. So this is kind of a presumption for you listen to the child if the child wants to come to court. 14. So just remember what I was describing. From about 9 to 14, the child's brain is reorganizing, cleaning out unused parts and memories and making room for the emotional intensity that comes their way. So at 14, a lot of these kids have been heavily influenced, especially by not having contact with a rejected parent. Maybe a court case has gone on, and court cases I've been involved with this go on for a couple of years at least. And during that time, the alienation grows. And it's important to know if the court allows the child to not have contact with a parent until it can be investigated, and there's no offer of abusive behavior that's been made, just the child doesn't want, so we need to investigate this. Then during that time, the child is exclusively exposed to the parent with alienating behaviors, and those increase. In other words, if you want to picture this, I think these are emotional analogies. And I talk about primitive emotional power in my talks sometimes, that these get to our unconscious mind. Think of a cult, or think of the Stockholm Syndrome, where hostages were taken and then they took the hostage taker's side and defended him and liked him. That emotions in isolation can be very powerful and make you survive by bonding with the person who's isolated you. And so what we see is early in court cases, parent says child doesn't want to see the other parent and brings that to court. And the judge often says, well, until the child's ready or until we understand what's happening, the father's or the mother's not going to have any contact. Well, there's numerous problems with that. One is your problem is going to get worse if it's alienating behaviors because you're isolating the person with that. Another is your information is going to get more and more distorted. So you're not going to be finding useful information. And if you do this at the start, it's really hard to overcome. And that's why courts have taken strong measures to overcome alienating behaviors, overcome alienation, and have therapeutic reunification activities, such as the camps. Sometimes it may be counseling, maybe a combination of these. But the emotions take hold. And if you picture this as a cult or as a hostage taking, you understand that the person is not very voluntary anymore. I'll give an example of Elizabeth Smart, 14-year-old girl, kidnapped and sexually assaulted by someone in the mountains, not real far from her home in Utah, and for 9 months. And they walked around the town wearing robes. He claimed to be, Brian Mitchell claimed to be a religious man, so he was completely covered. His wife and also Elizabeth Smart completely covered. And she was scared, and she had basically adopted that to be safe, I have to cooperate with this. And when the police first stopped them, someone said, I'm not sure if that person wants to be there. She said, no, I'm fine, you know, and for a few minutes was protecting her abuser. And this is the police. She could have just said, "Thank you, save me." Instead, she was, "No, I'm not who you're looking for, and leave us alone," basically. Well, the police were pretty smart there, and they said, "We want to talk to her separately." And they did that. And after a while, she said, "Yeah, I'm Elizabeth Smart." And they were able to save her from that. But the idea is people are really easily influenced and protect the people who have this emotional control. More and more, we're talking about coercive control in domestic violence cases, the control you can't see but goes on behind closed doors. In domestic violence cases, it's financial control, it's not being allowed to see relatives, all of these things. Well, the analogy totally fits with alienating behaviors. There's a coercive control, and a child submits to that coercive control. Because that's who has the power. Let me go to another state here, Colorado, and just talk about a summary of their law. Again, if the child or youth is of sufficient age and maturity and able to express an opinion. The bill requires that if allegations of domestic violence, child abuse, neglect, or child sexual abuse have been made, a child or youth must not be forced basically into parenting time with that parent. Well, we all know how many of the cases of alienating behaviors come with allegations, well, the other parent must have abused the child. And of course, the nuclear weapon with this is false allegations of child sexual abuse. And that's used as a way to gain complete control of the child by a parent with alienating behaviors when it's not true. Now, it's important to acknowledge there are true cases, but these are also a very, very small number. The research I've read says 2 to 4% of separation and divorce custody disputes include allegations of child sexual abuse. And maybe half of those are false, maybe even 2/3. So this is it's a real problem, but a small real problem in proportion to the reports people are giving now of 20 to 25% of contested custody cases having alienation, have resistance and refusal issues, many of whom are alienation cases. So that's much more prevalent than child sexual abuse. However, I should add that close to half of custody disputes in family courts several years ago, I was told, have domestic violence allegations. And I agree that the vast majority of those are true, although there's some that are not. So domestic violence is a big, big issue. Alienation is a big issue. And child sexual abuse is an issue. But the size of these, I think, belies the approach to solving it through legislatures. What's happening here is professionals understand this full range of possibilities, but the public doesn't, and legislatures don't. And that's why they went with the emergency cries of people saying child safety, child murder, and that certainly needs attention, and that certainly is important. But if you don't understand, why did judges order parents to have contact? If you don't understand this, and my experience is professionals tend to be towards that there's alienation or towards that there's abuse, but you have to have professionals that are very broad about all of this, totally objective about this. That's what you need to figure this out. Anyway, so basically, child or youth must not be forced. And so basically what that does is it gives the child a decision-making role that's quite powerful. And of course, child says, I don't want to see my father. I don't want to see my mother ever again, maybe. Then you can't force the child to see them. according to these laws. So they need to be changed, and that'll be part of the discussion later today. So I want to talk about the social psychology of children making decisions in dysfunctional families. So children's preferences. Can children make independent decisions in dysfunctional families? This is an article that I wrote in March of this year. It's available on our website for High Conflict Institute, and I included the link in the PowerPoint slides. I just want to read a couple key things. One is, for a child to resist or refuse a relationship with a parent is not normal and only occurs in dysfunctional families. And I want to say, I say that having been a therapist, child and family therapist for 12 years, and then a family lawyer for 32 years. Throughout this time, also being a family mediator. It's not normal families that have this problem. There's somebody in the family that has a significant problem, and it needs to be understood what kind of problem it is and which person is perpetrating the problem. So the question is why? Is it because of child abuse, domestic violence, alienation, or something else? It's not a problem to ignore or sweep under the rug by punting to the child. And that's what we're doing. If we say, well, the child says, so that's the end of the discussion. Child says. And these laws include a child doesn't have to say it to the judge. Child can say it to minors counsel, representative, a legal representative for the child, custody evaluator, a court counselor who recommends schedules like we have in California with family court services. So an investigator of some sort. Child says this to this, according to the current laws that are in or coming in, is it stops there because you can't force a child to do anything because this isn't, the right way to go, is what they're saying. So I think it's not a problem to solve by eliminating one parent and all of that side of the family, which is often the healthier side of the family. Most separating and divorcing families, about 80%, do not go to court to resolve their parenting decisions. I've done a gazillion mediations. Actually, it's probably around 2,000. Mediations with parents making their decisions, no interest in going to court. Their paperwork goes to court, but they don't. They don't have these problems. They understand they got to share the kids and that it's important for the kids to have a relationship with each other. They help each other out. They say, hey, I've got something this weekend. Can you take Johnny? And then I'll take him next weekend, which was your weekend. All the time, that kind of thing. And from my experience, about 80% of families don't use the courts to make their parenting decisions. So that means 80% of people have nothing to do with these kinds of problems, with a child resisting contact. Of child custody disputes in family courts, only about 25% or less involve a child resisting or refusing contact with a parent. So it's not even a majority of court cases. This is a smaller group. Now, this is resistance or refusal. So we don't know, is the cause abuse or is the cause alienating behaviors? But the issue isn't even present in more than about 25% of custody disputes or of parenting disputes. Some parenting disputes are about, smaller percents of time rather than who has custody. And we're trying to get away from those words like father's time, mother's time is much better. Anyway, so this is not a normal divorce problem. Children in such families cannot be independent. There's something wrong in these families. That's why knowledgeable adults need to figure out what's going on and what would help. And that's why I wrote this article, and I go on to explain some about that. It's just what's so disturbing to me is some real problems are being used to address a whole lot of other problems. And so what's happened in these cases, the child murder cases are terrible. I'm a social worker. I've been exposed to cases where this has been an issue. I haven't directly been involved, but been consulted on and such. And this is terrible. But you shouldn't make your decisions when you're highly emotional from just having seen a video of somebody's tragic result. Well, that's how these laws came in. Some videos of people resisting going to being forced to go to the other parent. There's cases of kids resisting that. There's cases of kids doing just fine with that. They reconnect with a rejected parent, and within, a few hours or days, they're back to normal. But there are exceptions where a child this is not the right parent. This may be an abusive parent they've been returned to. Or it's just been a failure of the process. But using exciting, dramatic, extreme examples, seeing videos, that's what's influenced people to push for some of these. I was at a recent conference with the Association of Family and Conciliation Courts, AFCC, the largest organization dealing with custody and parenting issues in separation and divorce. They have people from like 80 countries come to their conferences. And one of the sessions was on Kayden's Law, and it was presented by one of those driving forces behind it. And she included a video clip of a child who said, I was forced to go with the other parent who I had rejected, and it just was awful. I became depressed, this, that, and the other thing. I don't know what happened there, and that may have been a bad process, or it may have been a dangerous parent. I don't know. But to then make thousands of other families be bound by that case, and some of these other cases, that's the problem. So this is not normal kids in normal families. So here's what happens, and I learned this as a mental health professional. Kids carry the dysfunction of dysfunctional families. I had a family as a therapist, intact family. Mom had schizophrenia. And the treatment, at that point wasn't well. We're talking like 35 years ago. But medications were coming out. But the children basically reorganized themselves around this parent who was frequently dysfunctional. And so they tried to please the parent. They tried to calm the parent. And they tried to do these things. People with families, huge percent of families with substance abuse issues, kids cover up for that. They learn that early on. Kids manage their parents. They smell their breath when they come home from work to know whether it's going to be a good night or a bad night. So children adapt and survive. Children have to survive, and they have strong drives to survive. And that's why they're going to say what pleases the person with the most power in a family. And sometimes that's the most dysfunctional person, and sometimes that's the most responsible person who's managing a more dysfunctional person. But the idea here is that children get caught up very much in that. And anyone who's trained in family therapy knows that. Everybody in the family impacts everybody else. And the family wants to maintain stability and homeostasis, they call it. And so when there's pressure from outside on the family wants to defend its homeostasis. And if there's someone from the outside saying, this parent's a problem and this parent's good, if that's not what the child has experienced, the child's going to resist that. And what we see in alienation cases is that children tend to favor the more dysfunctional parent, because that's the conditional parent. the parent that wants the child to please them and dislike the other parent. The other parent who may be unconditional and say, I love you regardless of what, the child feels secure with that parent. And so we don't see the child worried about that parent. And I remember once seeing a docudrama about, I'm blanking on her name right now, but Wizard of Oz, Dorothy, she played Dorothy. And this is, 60, 80 years ago. But she had a bad divorce, and the husband was very stable, and she became an alcoholic. And what she did is the father took the kids to be safe. And the mother showed up and said, I want the kids. You've got to give them to me. And one of them was 12, I think, said to the father, Mom needs us. We're not worried about you. Mom needs us. So they went with her. And that was that story. And that's the pattern of behavior. Family systems have to be understood to understand parental alienation. And if we're not allowed to teach family systems, parental alienation, how emotions are contagious, then people aren't going to understand what they're looking at in many, many cases. So children go where the power is. And this is why the child should not be counted on to provide useful information. And what I say is, why do we believe that anyone in a dysfunctional family can be an accurate reporter, child or adult? Is we need outside people. We need a team of people. And that's what I suggest. A team of professionals with multiple sources of information is going to be much more accurate than a child who's going to say anything to survive. And I know of cases where kids have said afterward, I lied to the court for you, to one of the parents. I've had cases where the parents shifted and they wanted to get divorced. Then they wanted to reunify with the parent that they had rejected and the children had rejected. and getting them back together, not all the children wanted to come back together because they had lied in court against that other parent. And now they're being asked to move back in with her. So what should be done? There's several things. I've got 7 points I want to make here. First, these laws need to be changed to address the full range of resistance and refusal causes, including alienation and loss of family relationships. And one thing I noticed behind these laws were statistics. They had numbers, something like 600 children murdered in the last, where did that go? 15 years, something like that. And that's terrible. And that impacts people. It kicks you in the gut. You want to do something, anything. And that's what the legislatures have done. Well, people need to hear about the thousands of parent-child relationships that have been lost because of alienating behaviors. People need to learn about the impact of children siding with a more dysfunctional parent and how that's going to impact their development, not having a more healthy parent in their life, and also learning all or nothing solutions. So the laws need to be changed to address all of these possibilities. We need to acknowledge the seriousness of child safety and that physical child abuse, child sexual abuse, and domestic violence exist and are all real problems. It's not either or. It's both exist as public health problems. And advocates around parental alienation, advocates around abuse, often talk to themselves. And one thing I've noticed as a basically high conflict focused professional is that all of these are part of high conflict. And we need to understand what's going on in this real case, because we can't have presumptions. And I believe we have to say it's not either or. We have to consider at least 3 theories of every resistance and refusal case. One is someone says the other parent's acting badly. You have to consider that really may be true. We have to respect that and let that be looked at. The second is it's not true at all. And it's the other parent who's making these allegations who's acting badly, often behind the scenes. The third possibility is it's a combination of behaviors by both parents. What's the solution to all of this? The thing is to try to treat these behaviors to the extent possible and protect children to the extent that people won't be treatable. And we don't know who's treatable and who's not, but many people are treatable, and that's part of, as mental health professionals, as High Conflict Institute, we try to promote ways to help people change some behaviors to make things safe. The third is the general public and legislators need more awareness of all of these issues impacting children and families of separation and divorce. They've only listened with one ear. It's the sound of one hand clapping. And there's this whole other hand that's basically not just ignored, but these laws are hostile to information about alienation and methods of reunification. These laws are hostile to that. And I would suggest that the legislatures in making these decisions have been emotionally hooked into feeling like, wow, this is a problem and this hammer is the solution, and that they're uninformed. And we see that across the board, is that when people are emotionally hooked, they're often uninformed and make bad decisions. And that's exactly what we're seeing. I hope it's not another 30 years before legislators realize, like professionals have, that all of this exists and we need to understand and deal with it. Fourth, judges and other court-related professionals need to be trained in the full range of abusive family behavior, including alienating behaviors. In other words, the way Kayden's law says it is they need to be trained solely in child physical abuse, child sexual abuse, and domestic violence. And if you have a chance to look at that, look for that word solely, because what that means is we want to deny them looking at other possibilities. And that's terrible for training. I have opportunities to speak to judges. I talk a lot about high conflict behavior, managing high conflict litigants, using our methods like BIFF emails to have parents communicate better with each other. So I get to talk to judges. Judges want to understand. You know, when people don't like a judge's decision, sometimes they complain, well, the judge was biased, or the lawyer on the other side must be paying the judge, or things like that. None of that stuff fits our family law judges. Our family law judges are very sincere, probably the sincerest group of people I've ever met. The problem for them is that they're often not aware. They're not aware of all the important information in a case. They're not aware of all the mental health background that could exist in a case. It's a lack of awareness is the problem, not evil intent. We just have to really help people move away from that kind of criticism. It's misplaced. The biggest problem in this whole entire field is lack of awareness, lack of knowledge. And unfortunately, we've just been pushed back to let's keep ourselves ignorant of alienation issues. And like I said, hopefully it won't take 30 years to overcome this. From the start of a case, and this is important in my thinking, judges and other professionals should not allow or encourage children to cut off contact with either parent. So this is what happens early in a case. One of the parents says, you know, the child doesn't want to see his mother, doesn't want to see his mother. So, Your Honor, I'm asking for an order that gives me full legal custody and physical custody. And when the child's ready, then, you know, that can be changed. But right now, child doesn't want to see his mother. He's complaining about his mother. The tragedy here is the courts and other professionals often say, oh, okay, let's go with that and then look into it. Maybe we'll have an evaluation. Maybe we'll have a full hearing and figure out what's going on. You don't have time to figure out what's going on in terms of still having a relationship with each of these parents. If there's a terribly abusive parent, usually you can have supervised contact with that parent and the child will be safe. And so, and if there's no abuse and it's an alienation case, the parent's not going to be separated from the child while the child absorbs all the alienating messages in isolation. And so right at the beginning is when the damage begins. When the court and other professionals say, oh, okay, well, we're not going to force Johnny to see his mom until we figure this out. And then, as most legal professionals know, figuring it out often takes a year or a couple of years or at least 6 months. And by then, more and more damage is being done. Most of my alienation court cases, it grew during the court process as the parents became more and more upset and frustrated, and the children absorbed that. So from the start, judges and other professionals should not allow or encourage children to cut off contact with either parent. Alienation grows when allowed over time. If necessary, supervised contact is better than no contact. And what's interesting with these laws is no contact with a parent who's alleged to be abusive is fine. No contact with the parent making the allegations is absolutely not allowed. Well, in the alienation cases, that's the person who is the source of the alienating behaviors. What we should have is an across-the-board look at, let's not allow no contact with anybody. Let's have supervised when necessary, but let's not allow it to even get started. Now, I don't say it in my notes here, but I've said this before in some of my other trainings. I believe judges at the start should ask the parents 3 ways they're going to protect the children from their upset emotion during the divorce, and to say 3 positive things about the other parent, because that's going to really help block the development of alienation or the increase of alienation. I also think it helps if a judge reads through a list of things. Thou shalt not tell the child you're having a court hearing about custody. Thou shalt not tell the child you can't afford something because the other parent doesn't give you enough support, or because you're giving the other parent all your money for support. Thou shalt not. It's these thou shalt nots. At least 10 things you can think of, probably 100, is to warn people up front, don't do this. Because the reality is 80% of parents automatically don't do these things. But the 10 to 20% of parents who may do these things need to be on notice. You're not supposed to do this. Don't show your child court papers. It's hard to believe that that has to be said, but I believe it helps if a judge does this. It doesn't have to take more than a minute, but laying this out at the start. The way these cases start is what we can do something about, and what the judge can do something about. What to do if it turns out that there's alienating issues and a judge wants to order some reunification counseling or other efforts. Right now, their hands are tied. But the front end is really the better place to stop alienation from growing and basically say, remind people, the legislature says both parents are to have a significant relationship with the child. That's the words in California, a substantial relationship, all of this. If there's safety issues, of course, that trumps that. But we need to figure out, is this a safety case or not, pretty quickly. And I believe in the first 30 days, this can usually get figured out, what's going on. And you can't base it on the child's behavior. You can't say, well, the child resists the parent, so the parent must have done something. You can't do that. You have to overtly think to yourself. This is like, the person on TV that's being held hostage in another country, and they say, I'm being treated wonderfully and everything's the way I want. Well, you can't assume that that's the case. Now, kids will say that and believe it when there's enough repetition. And I like to use the term ERI, ERII. Emotional repetition in isolation breeds alienation. So it's that repetition and the isolation we want to avoid. Okay. And the last is court decisions need to be allowed to include reunification counseling of all forms based on the needs of the case. So we need to go back to the options available, but we need to educate people better. And that's what we're doing with High Conflict Institute. We're an educational institute. We really want to teach people. And I'm involved with domestic violence advocates groups, and I'm trying to teach them what's going on in those cases. I teach about personality disorders, what drives some of that behavior, but also that there are cases of alienation, that we're not two camps that are enemies. We should not be enemies. We're still some of that field. Professionals have pretty much found a middle ground and realize all of this exists. And I'm involved with alienation advocacy and understanding that, this stuff exists and we need to deal with it. And again, it's often rooted in personality disorders. Personality disorders are estimated to be 10% of the adult population, according to the DSM-5-TR. And they drive abusive behavior, and they drive alienating behavior. So we all need to learn more about that and talk to each other. And I really like the work of AFCC because it brings all of this together, and they have workshops on all the different points of view. So hopefully all these efforts will eventually lead to informed decisions. So that's court trends and why we shouldn't let the children decide, even if they're 14, 15, 16, or 17. Best wishes, everybody, and have a good conference.